By calling us and telling us what you have done, what you have not done, is it a sign of weakness or you are trying to correct something?
You said you but all questions are okay from modern people, villagers, whoever, please as citizens. Yes, yes.
You set out one, we continue to see several of the away from the what are you doing? Then different of what you do. Saying you go to shape table. What do you expect to see? Away from shape table, kind of going to involve with the families. And probably together with in terms of improvement services. From the tables that shape what is there to show us as you have to shape
Thank you. During your time as leader of opposition, did you set out your goals? And if at all you achieve those goals, what is your strategy for the remaining term as leader of opposition? And then secondly, you've already seen the family of the late Hamad Sedili endorsing one of their favorites as the National Unity Platform. Are you going to back the preferred choice of the family? Thank you.
That's the preparation.
Change kiri walabona naise tekale mwana yasuuza okugamba nti bagenda kukolawo kike muli mukolawo era mutuuseewa
Okay. Mr. Olwen was the first to ask. Political prisoners, and maybe I should have led Parliament our side to boycott again. By the time I became law, we had already returned to the House. We were moved out and moved back in. Of course, many people complained and said, now, you went back. Had you achieved what you had hoped to achieve? I think the leadership at the time maybe had another strategy. I don't know, but we were fully in the House. What's important is that there has not been and there should not be silence about this issue. Both on the floor of Parliament, as you have seen, but we say let's take it even outside of Parliament. We decided to file a court case regarding these missing persons. Because we said we shall engage all avenues that we have available. So we were telling court, can the state account for these people? What happened? The High Court judge let us down, obviously, because the ruling was that we have not proved enough that these people are missing, which was problematic because we wondered how do you want us to prove? Because family members, here are their national IDs, they had families who were present and so on. And those who saw when they were being abducted were present, and they have been missing for 4 or 5 years now. So we found it problematic that court was saying, adduce more evidence to show that these people are missing, as opposed to demanding that the state accounts for these people, because the state is responsible for everybody. Anyhow, that's a ruling we appealed. We are appealing because the state has got to be asked to account for these people. So that's another avenue that we engaged. You normally see us every so often organizing prayers, going to these people's homes and so on, to meet them, to talk about these issues. Why? Because we don't want silence about this issue. Because that's what the state wants, that we forget about it and move on. We have said no. At every opportunity, we'll keep talking about them. We visit their families, hold prayers to continuously talk about this issue, because the moment we cease to talk about it, it will die. That's what the state wants, and we shall not do so. Collaboration, the Lumubin, maybe I'll tie that in with, there was a question about, somebody asked that we're seeing you with a few people here. This is the shadow cabinet. Unlike Mr. Museveni, who has a cabinet of maybe 100 people, our shadow cabinet is smaller, yeah? And we are showing the nation that you can run government with a small team. Yeah, so this is shadow cabinet. We do not have to have every member of the opposition. Besides, we also want them busy in the sectoral committees, because actually even some shadow ministers, a few of them are not here, because they are following up on the budget framework paper. We are going to produce alternative ministerial policy statements, yeah? So this is part of the shadow cabinet, a small team which can be effective. You don't have to have everybody and their mother being part of cabinet, as we see our colleagues on the other side. Sechunga, opposition, within opposition. You see, interestingly, when I took over leadership, I found an already fractured opposition. You know, really. I had taken long without being in a meeting with our colleagues from UPC, including the party leader, but some of the opposition caucus meetings that I've chaired, he has been in those meetings and he has guided us as a senior legislator and so on, and that was a good thing. We might have a few disagreements, but for me it warmed my heart to see that happen. It had not been happening previously. Yeah, parties have got their own issues. You know, within FDC, you'll have our colleagues at Katonga, you'll have our colleagues at Najana Nkumbi, but for me, I said we shall work with everybody. Me or the Honorable Anna Adeke, who belongs to Najana Nkumbi. We also have within our team people like Honorable Semujunganda, who is our Shadow Minister of Finance, belongs to Katonga, and so on and so forth. And we work together. Yeah, so it's not easy, especially when there are issues from, you know, the political party headquarters. Democratic Party, the leader of the Democratic Party works in government as a minister. His members are saying that's not our president, but I said I'll work with everybody. And that's what it should be. So I'm actually glad that there is some progress. Because when I see, you know, some of the opposition caucus meetings that I have chaired, I see faces that surprise me, that warm my heart, and I'm like, I'm glad this one is here. He or she doesn't agree with this one, but we are here to do the work that we ought to do. So yes, there are challenges, because like I said at the start, some people did not agree with my leadership, but that's okay. They said this Joel is a young man. What experience does he have? Because in the history of leaders of opposition, I think I'm the first to occupy this office in my first term as an MP. So some were saying no, and there are others who have been around for long. The man is just, that time I was 37. The man is just 37, what is this? And there are other people who are older. People have a lot more experience, but leadership is such. God chooses somebody and says this is the leader. But I'm glad I continue to work with colleagues. So there are those who to date, either they felt it should have been them to have this position, so they're not happy that I'm the one occupying it, or they were unhappy that they were displaced and it is Joel in. But we continue to work nonetheless. Yes, some MPs not vocal in committees and so on. It's actually resemblant to what I said earlier on. Whether it be in committees or plenary, there are some voices you expect to speak that don't speak. There are senior people whom you will expect to condemn certain things, violence, corruption, and so on, but they are quiet because of the issues that I elaborated earlier on. So again, it's not incompetence, it's lack of integrity that we need to deal with. Isa asked about electoral laws and so on. There's been talk about electoral reforms, you know, that we should be pushing for electoral reforms and that kind of thing. And let's be honest with each other. The issue that Uganda is grappling with is not a legal issue. Our laws, even though our constitution has been tinkered with left, right, and center, our laws actually are some of the best world over. And I'm saying that as a lawyer who has challenges with our country, but I know for a fact that our laws, if followed to the letter, if implemented as should be, would not be having the problems that we have. So our problem is not the law, because now, if you say that our problem is the law, how is it that even the laws that are in place, because the laws, for example, talk about how people should be arrested, but people are just abducted, you're not following the law. So is the problem the law? People being abducted, people are granted bail, and then rearrested thereafter. Do you say I resolve this by amending the law? Let's be serious. Let's also be political and wise, I would think, because sometimes people say they have too much wisdom. We need to begin to apply this wisdom, in my view, politically and otherwise. Yeah. Our problem is not the law. The laws as we have them, if they were followed to the letter, there's no law that says you should rig an election. Which law? Which law says you abduct opponents of of the government because they are wearing a T-shirt of an opponent of another candidate? Which law? Which law says now, because you see there are some polling stations, and you cover these things up country. People get to the polling station and they tell them, here we have already voted for you for president, you only vote for MP. Which law says that? You saw the ballot stuffing that happened, critiquing, by soldiers and so on. Which law allows that? So we need to put our energies where we should. So the issue, realistically, is not so much the laws. It's not so much the constitution. It is the lack of constitutionalism, the spirit of the law. That's why, even when courts of law will issue an order, a directive, and it is disregarded. So are you going to amend another law? Because the law is already very clear. The court has issued an order about something. See how the court martial is behaving. So are you going to say, let's amend the law, let's bring a reform? No, we need to push for the respect of the rule of law as it is. So let's focus our energies where we should. Somebody asked about Honorable Segi Nyabeli. I need to avoid that question, but I know you might say, hey, why has he dodged it? He has feared it. It's okay. I will respond to it this way. Firstly, Honorable Segirinya Mohammed was a member of parliament belonging to the National Unity Platform, and for that matter, the opposition in parliament. I was his leader. I have been his leader in parliament. Now, again, we need to apply wisdom. Yeah? When you're to give a decent send-off to a member of parliament, what is befitting to them, why do you put in place a one-man committee? Why? If really you want to respect anyway, why? Some were saying, let's go the other side. Others were saying, let's respect the wishes of Honorable Sekiri as a family, let's stay here. So even the family was divided because you've not brought them on board. That's the mistake that was made. And it was deliberate, I think. So if you want to respect a person like Honorable Sekiri, respect his family, respect his party which he loved, respect the side he belonged to in the opposition. But when you decide to put in place a one-man committee, disregarding all the other critical stakeholders, you have a problem. You have not applied wisdom, in my view. That supersedes the wisdom of other people. I have seen some people who have said there are some politicians who need so many years to get to the wisdom that I have. Okay, you show the public that you are wise. Because any smart politician, really, any smart politician, you apply that wisdom. So I think that's the problem that happened from the word go. And that's the response that I have. I think it's Toheyo who kept shouting, honorable, honorable. I'll not be dragged further in that issue. Ali Mifre, please withdraw. Ali, withdraw. Oh, not Toheyo, sorry. Jimmy. Yeah, so that's my response to that issue. You might not be happy with that response. You also go and hold a press conference after here and you say what you want to say. Have you heard Jimmy? I'm going to finish mine in a few minutes. So you call your colleagues either on the veranda or parliament or whatever, and you also tell them what you want to tell them. Again, trying that in, somebody said the family of Honorable Segirinya has declared that they are endorsing somebody, and they are saying NUP should give the flag of the party to that person. As a party, we are going to follow our processes. The same processes we followed to eventually get Honorable Segirinya to be our flag bearer, and the processes that we are going to follow to that effect. Why call us to tell us what you have done? I called you here so that we can interact. So that we can interact. And that's why you're asking the questions that you're asking me. And it's good you considered and said, but we have seen the things you have been doing. Why are you calling us to tell us about them? There's no harm in us interacting on this anniversary and giving some kind of accountability about what we have been up to. It's important to keep doing that as and when we can. Juma, issue of political prisoners and so on and so forth. The other strategy that we have employed, as opposed, in addition to using all the avenues we have, going to court, even though we know that there are challenges in court, we said, okay, let's use that avenue there. Let's keep engaging the families, bring attention to this issue and so on. We have been calling on religious leaders to come on board. Shortly after I got into office, you saw we held a meeting with the Interreligious Council of Uganda, led by Archbishop Dr. Kazimba Mugalu and the others. And we're saying, please, we want to hear your voices on this issue as religious leaders. It's important. And I'm glad that many of them nowadays, they keep speaking about it. You see it. You see it on Sunday, in cathedrals, in churches. You see it on Fridays in mosques. That's also an important element. Because when it is just us politicians speaking about these issues, you kept hearing how some were dismissing and saying, no, you guys took them in Canada, you took them abroad. Are you going to tell the same thing to a religious leader or a cultural leader? So we are glad that all those voices, as we kept engaging them, they are upping their involvement. Namayo asked, did you set out goals? I thought that's where I started. I told about our three key priority areas, and I told you how far we have gone regarding those. To hear you asked about the coffee bill and all the others that were passed in a problematic manner. We have told the coffee farmers, number one, grow more coffee. If it was the ploy of government to discourage you from growing more coffee, please don't fall for it. This government is going to outlive the coffee that you grow. And so we have said, as coffee farmers, let's get on board. Voice those concerns. The election is around the corner. Use your ballot as a stick against this government, which wants to take everything away from you. Use that voice as well. As MPs, we have got a part to play. Yes, we did, and we shall continuously do so. You saw what happened in the House. Our colleagues being roughed up, lights switched off. You, the media, you were locked up. You were prisoners and that kind of thing. So as we keep doing our part, we are telling the people out there, the 12.5 million Ugandans who are involved in the coffee value chain, speak out with your vote as well. Yeah, because it's important. Don't allow for things to be taken away from you as if you're voiceless. Olwen yabuziza, yes, bannaffe abawambibwa abali makomera era agambye nti lwaki twafulumya ababaka wena twalira obukulembeze buno palamenti twali twagiddamu dda fatu waliwo abaali beebuuza naye kaakati twafuluma ate nitumala netuddayo nga netupulanize bulungi tugenda kikwasaganya tutya naki naye twali twaddayo dda so nga palamenti egenda mu maaso ffe ne tugamba nti bwewaawo tujja sigala nga twogera ku nsonga eno ku fulo ya palamenti nga webuze muwulira naye netugamba netwagala ekomaawo netugenda ne mu kooti twatwala omusango mu kooti ku lwa famiri z'abannaffe bano nga tugamba twagala kooti eteeka kasito ku gavumenti ewe embalirire y'abantu bano ewe accountability abantu bano gavumenti ebavunanyizibwako baluwa of course ekyatujja enviri ku mutwe kooti yagamba nti kaakati bano temutuwadde bujulizi bumala nti okulaga nti abantu bano baabuzibwawo netugamba omulamuzi ono abadde atya tukuleetedde famire zaabwe ziizino abaana baabano national ID zaabwe ziizino ekikulaga nti baali bantu baaliwo tetukijingirira bujingirizi. ID gavumenti yazibawa abantu bano oyagala tukole ki ekirala, naye twagamba nti tugenda kwapiiringa ensonga eno kubanga tetukkiriziganya na mulamuzi ono kyeyasalawo, kubanga tukoze buli kimu. Abantu bano bawambibwa n'abaliwo nga babatwala bonna boogedde. Kati bw'ogamba nti tuwadde bujulizi bumala okulaga nti abantu bano bawambibwa oba babuzibwawo, kyekirala kyoyagala tuleete. Wali badde oteeka akazito gavumenti ew'embalire y'abantu bano beyawazi national ID baafa baziikibwawa bwebaba baafa baliwa. Bwegamba nti nga mwawulira abamu nti abo babatwala e Canada naki baafulumirawa bayita ku ziboda mutulage bwe baafulumira. So ensonga zino zonna tukyazigoberera nga bwe tukyalina ezifamire muze mutulaba nga tukola enyimbe okusaba era ku kitebe kyaffe nga NUP abantu bano gye babeera. Bino byonna tubikola okulaba nti ensonga eno tusigala tugiteekako tooki ereme kusirika. Baagala tusirike biggweeraawo nedda. Buli mukisa gwe tubeera nagwo tujja kukozesa okwogera ku nsonga zino. Waliwo ayogedde ku collaboration omubiru n'ebirala era kankigatte neyagambye nti ababaka booli nabo nga batono. Sookera ddala eno shadow cabinet yaffe terimu abayitirivu n'abatalina byakukola ng'eya Mwai Museveni yaffe yabatonotono. Tulaga nti tusobola okukola emirimu nga kabineti nga tetuli bayitirivu nnyo. Naye n'ekirala nze kye neebaliza Katonda nti newankubadde natwala obukulembeze nga opposition erimu emiwaatwa mingi okubira ddala ku bitebe byaffe aba UPC nze nali ndudde okubalaba mu zi meeting zaffe ezimu. Naye kati nkubiriza opposition caucus meetings nga Honorable Jimmy Akena waali n'abalala aba-DP balina ebizibu byabwe ku kitebe kyabwe era nabo tubeera nabo mu meeting zaffe. Aba FDC tulina abannajja n'ambumbi nga Honorable Anna Adeke, tulina n'ab'e Katonga nga Honorable Simujju n'abalala tubeera nabo mu zi meetings ezimu. Ekyo nze kimpa essanyu nti newankubadde tulina obutakkaanya bungi naye tugamba tusisinkane era mu zi meeting ne tuzibeeramu. Kye nali ndudde okulaba kuba nali ndudde okulaba abantu abamu mu meeting zaffe naye babeeramu newankubadde yes tulina obutakkaanya mu nsonga ezimu. Naye naga bwe nagambye nti yes mujja kubeeramu abamu babagamba nti Ssennyonyi oyo yatwala obukulembeze nga mwana muto. Tubeera nako na leader of opposition ali ku myaka 37 nedda kulwaki netubeera leader of opposition nga kyekisanja kyekisoose mu parliament kibangawo ku bannaffe ababaddewo mu ofiisi eno naye munnange omutonzi waffe yasalawo ku nsonga zino. Kakati bannaffe abamu bo nga bagamba nti naalibadde nze ekifo kyali kibadde kyange kati oyo ojja kuyita meeting tajja kujja. Agamba nti ffe mwatujja mu ntebe mwatusuuza ekifo nabo tebajja kujja naye mujja bawulira eyo nga beemulugunya abo bye basalawo bye bakola bikyamu era tebitegerekeka. Jangu muzi meeting otuwa amagezi go amasukulumu ennyo tukawulirize. Naye kati toze muzi meeting zaffe naye oli eyo weemulugunya bye basalawo bikyamu naki oba osazeewo butajja muzi meeting sirikira ddala. Yes ababaka oluusi abatawogera nnyo oba muzi komiti naki kyekiri kye nayogeddeko abapya ne basiniya naddala basiniya basuubira okwogera ku nsonga ezimu nabo basirifu. Kulwabiri bye nayogeddeko kutiisibwatiisibwa kungi wano ku palamenti obwesimbu butono sente ziyitingana mpitirivu naye nga ababaka ate bamanyi ekyokukola naye tekikolebwa. Ensonga ey'amateeka g'ebyokulonda mutera tubuuza nti kakati electoral reforms nga temuzitaddeeko sira banaye tubeere bamazibu tubeere serious tubeere bantu bakulu. Ekizibu Uganda kyerina si mateeka kubanga n'amateeka ge tulina singa gagobererwa eggwanga lyaffe lyalibadde bulungi. Waliwo etteeka erikiriza okubba oba obgesende obubaka luno. Waliwo etteeka eriga nti kakati wamba abo abatakuwagira mubasibe olwokubanga baba babadde t-shirt ez'omuntu omulala obaki. Amateeka gali clear naye tegagobererwa. Kyovudola omulamuzi ayinza okuwa order ne gavumenti kati tujja gigoberera eyo. So kati obuzibu bwe tulina butagoberera mateeka. So kati kyekizibu kye tulina okugonjoola. Tukigonjoola ng'ogamba nti kakati tulongoosemu amateeka tukole amendments oba ne reforms. Obuzibu si mateeka kubanga ne bw'onoogatereeza otya gano agaliwo olwedde ge batagala kugoberera ne bw'onooleeta amateeka amapya era nago tebajja kugagoberera. Kati tulina okutegeera obuzibu buliwa ng'abantu abakulu tukole ebintu ebijja obuntu bukulu bwaffe. waliwo yabuuza ku kya Honorable Segirinya obuzibu bwe bwabadde. Honorable Segirinya abadde mubaka nga wa NUP nga mubaka ku ludda oluwabula gavumenti lw'enkulembera. Paalamenti ng'emusiibula mu kitiibwa kye waliwo ebintu byalikoze, ebintu eby'ekisajja kikulu eby'amagezi okulaba okwange. Baagenda ne bateekawo komiti ya muntu omu, one man committee, okukola otuli kintu bwe kityo. Nze abadde amukulembera mu paalamenti nga sibimanyiko na bigenda maaso oba wali kakiiko oba ki. Lwaki? Oba nange tunyaliriza ne tuteesa ku nsonga kuba nze mbadde mukulembera mu paalamenti. Ekibiina kye kyabaddemu nga NUP kyabadde ayagala ennyo era yalama n'okulaba abamusajja batu ng'amanyi anaatera okugenda. Njagala bikolewo ebiti ekibiina kyange bwe kiti mukulembeze wange ebintu byonna byonna. Lwaki tewayitayo kale mukulembeze omu okuva ku kitebe kya NUP abeere kakiiko family oba family ne baali bagiwa orders just mukole kino omuntu akikole tujja bawa ssente okuva wano mu paalamenti oba ki nedda nabo batule ku mmeeza ffenna tubeerewo tuteesize omukolo guno ogusiibula munnaffe. Kyodula ne family nayo bajawulamu ng'abamu babatiisizatiisiza bagamba naye tugende eri gye bategese, abalanga bagamba nedda ffe nga family tusazeewo okuwa ekitiibwa Segirinya kye yali ayagala tugenda sigala wano. Kati olaba ne family nayo gyawuddemu kubanga tewabaleeta ku mmeeza ffenna tukkaanye. Lwaki tukola ebintu ebyekyana ekito bannange ne tuweebuula munnaffe bwe tutyo? Kyali kikyamu era tulongooseemukko. Ekyogaa nti otaddewo one man committee ng'ate waliwo ba stakeholders abalala Segirinya bazaayogerako abamanyikiddwa abayagala ennyo abadde bamukulembera mu paalamenti n'awalala n'otusamba emabega ebbali. Era kyokutulaba abantu bagamba nedda kino tujja kikkiriza. Embeera eyo teyali baddewo singa ffenna nga ba stakeholders twabeera ku mmeeza. Segirinya tumuwa ekitiibwa ekimusiibula obulungi. Weewaawo baagaana okumuwa ekitiibwa kye nga mulamu nga bwe mwalaba. Bamuyolanga omubbi w'enkoko ne bamutulugunya, bamutadde mu kkomera, bamumye ebbeeru n'agamba bannange mulamuzi nyamba ndi mulwadde. Government doctors ne basayininga ebipapula omuntu ono mumute afune obujjanjabi, mulamuzi n'agaana okumuwa bbeeru. Olwamuwa bbeeru yali afuluma Kigo prison ne baddamu ne bamuyoola. Bamutyoboola mu bulamu bwe ne mukufa ne basalawo bamutyoboole. N'otawa kitiibwa bantu be bakulembeze banne bazaatambula nabo. Kyali kikyamu bwe buswavu obwaliwo ku nsonga eyo. Waliwo abuuziza nti famire ya Honorable Segirinya era egambye nti bo balina omuntu gwe baagala aweebwe kaadi ya NUP. Ffe ng'ekibiina kuba nze nkyogere tulina emitendera gye tuyitamu omuntu okufuuka flag bearer waffe era ne Honorable Segirinya emitendera gye gimu gye yayitamu gye tujja okugoberera okufuna anadda mu bigere bya Honorable Segirinya. Wali abuuziza nti lwaki otuyise byozookola ne banno tuze tubiraba, lwaki otuyise okubitubuulira kirimu sitaani netujja netuwayamuko ku nsonga zino netubabuulira kuba kakati tuwezesa omwaka tulinga abacelebratinga birthday. Kakati lwaki mutulemesa okucelebratinga birthday netubajjukiza? Omanye muli bakujjukiza mmwe kyetuliko okubajjukiza. Juma yabuuziza ku Yesu political prisoners ne ba stakeholders abalanga bwe ngambye nti yes nga tugenda mu kooti naki naye twagamba ne ba stakeholders abalala nabo katubeegatteko. Twagenda shootinga nagayingirawo mu ofiisi ne bannange netusinkana interreligious council netuwayamukko ne bakulembeze bannaffe mu ddiini tubasaba nabo mwogere ku nsonga zino kubanga ffe bannabyabufuzi bwe tuzoogera kubagamba byabufuzi just era njagala kwebaza bannaddiini abamu mubawulira mu ekereziya mu makanisa mu mizigiti nga boogera ku fukambi nga boogera ku bulyake nga boogera ku tulugunya abantu abaawambibwa tubeebaza. Kiba kyanjawulo nnyo ng'amaloboozi gaabwe geegatiddwa mu gaffe. Yes, namale yabuuziza goals zaffe twasetinga nakyogeddeko kyetwatandika nga tukola. Finally ensonga ya coffee bill era nga amateeka amalala kyenjagala okubiriza omulanga bannansi nti tubinge interest bigenda maaso era kizi kibeerawo nga mubalaba nabo bwetwogera ku nsonga ezimu nga babayo nga beekalakaasa naki. Abantu abeetaba mu nsonga ez'emmwanyi bali obukadde obusoba mu 12 bannayuganda. Tubagamba nti olutalo lwaffe nammwe okusingira ddala lwammwe ffenna twetabe mu nsonga zino. Akalulu kasembedde abababbako ebyammwe mubagobe mukagube kubanga bajja kozesa olukujukuju bakozesa ssente bakozesa okutiisatiisa mwalaba bajjako amataala nga tuteesa ku nsonga eno bannamawuli ne babagoba abayaaye ba SFC ne bayingira ne batandika okuba ababaka nakinaki babikozesa byonna naye mulina amaanyi nga bannansi mugakozese kulaba nti mwirwanako mwebale nnyo basemuli banyabo
If I am a cook and I decide that the porridge I have been asked to make for this morning has my assessment issues, and I refuse to make the porridge. As a result, people go out in the unit, they are hungry, they are ambushed, and they have no energy to fight. Can be charged with that offense. What can we do today? That is if I refuse. If I don't refuse and I make the same porridge, knowing that the also may not be issue, we have to eat, people have to go out, and people go out and they will run the store. I can be charged with that offense. If you do, if you omit. Now, Mr. Chairman, it would be useful if the court looked while it's considering this application. Look at the rest of the paragraphs, 128(1)(a) to E, because they are very specific as to what it is a person disclosing by word of mouth the document information to the agent. That is clear. Discussing confidential information, giving a password to somebody who's not qualified. And then at the end of that whole section, if you do anything or omit to do anything, Mr. Chairman, I contend the offense is not defined. Article 2812 deals with gist of it. The purpose for it is to ensure there is no vagueness. So it is a constitutional standard to deal with vagueness. And why is there a problem with vagueness? Is simply because you can have overreach. The application of the section depends on the whims of the person who decides that it applies, it doesn't apply. The gentleman making porridge. I maybe have to hold it up in the air shouting that I have just disarmed this person, I'm not committing an offense. This is a big problem in our assessment with that provision. So, Mr. Chairman, it is the contention of the accused person that offense is written in words that clearly show that the people who drafted it had run out of the clarity. Then they just said, let's just also put a net and see what else we can catch. We want to catch Nile perch, but let's put a net. If we also get mokene, we get worms, we get stones, it's okay. Let's just catch. But the whole intention was we wanted to get Nile perch. So, Mr. Chairman, honorable members, it is our contention that there is a question that arises with regard to section 128, 1F. The question that I will pose to the court is simply this: whether that section 128, 1F of the UPDF Act is defined in terms of, and therefore consistent with Article 28(12) of the Constitution. Honorable Chairman, General Court Martial cannot answer that question because, as I said earlier, the role of answering these questions is the preserve of the Constitutional Court under Article 137(1). We trust that the Court Martial is part of the UPDF, the law-abiding citizen institution, which is why I refer to the attributes of the force which must be professional and disciplined, and is aware that it must subordinate itself to the provisions of the Constitution. We find this question one that we will refer for interpretation. Mr. Chairman, there is another question that we would like to also pose. And it's a question that has arisen here separately, but continues. And it is so fundamental to the trial of especially the two civilian gentlemen that it's imperative that it be addressed. Mr. Chairman, again, Article 28, Sub-Article 1, spells out the standard that is expected, that is required, from which there can be no derogation as far as a fair hearing is concerned. Fair, speedy, public hearing before an independent and impartial court. Independent and impartial. The cases, Mr. Chairman, that have dealt with the issue that I am addressing you on, the trial of civilians, are many. Captain Amon Yagaba is one such case, 2015. Attorney General, Uganda Law Society versus Attorney General, 2005. Attorney General Joseph Mushabe, 2005. Michael Kabaziburuka, 2016. They have all said the same thing. And that thing is that with the setup that exists in the structure of this court, it is impossible for there to be a fair hearing. They have addressed questions of independence, they have addressed questions of impartiality. And I say this, Mr. Chairman, with all the humility I can, all the respect, but taking you back to the attributes of the force being subordinate to civilian authority. The judiciary has said this is the position. Then the force and its owners must subordinate themselves. Because to do otherwise, Mr. Chairman, is to say organs that the officers and men, the wonderful officers and men that constitute force, can rise above the Constitution. If that route is taken, if that view is entertained, if that thought even crosses the mind of anybody, then the entire 150 words on the preamble that I spoke about are useless. We get right back into tyranny. You must distinguish yourselves from those forces that did not abide by the Constitution. Mr. Chairman, in light of those decisions, the ones I have cited, and I know Helen Fred will say one of them had a stay. It is true it has a stay. It is a stay on implementation, not on interpretation. When you read Ammon, Captain Ammon, the court there was very clear. Until the ethics court has pronounced itself on the interrelated issue, it's a paragraph dealing with Kabaziguru. Michael Kabaziguruka, the Attorney General, as well as ULS and the Attorney General, both of which I have cited, remain good law for the present purposes. Mr. Chairman, the law now is as interpreted by the Constitutional Court. But we can't be here. Even if we want to, we can't. We can't. Unless we are elevating ourselves above the Constitution. If we are, then we can be here. But if we are not elevating ourselves, then we must abide by what that those decisions say, until there is a call for the decision. There is no, the stay, I'm sure my land friend will refer to it, the stay does not remove the interpretation. And the importance of the Constitution, I don't know what words I can use to express how important is to abide by the Constitution. Mr. Chairman, the question I would like to frame and proposing the framing is this: whether in light of the decisions of civilian courts, both the Constitutional Court and the Supreme Court, regarding the trial of civilians in the court martial, both the Constitutional Court and the Supreme Court, regarding the trial of civilians in the court martial, the conduct of the General Court Martial as an organ of the UPDF, to try two civilians is consistent with Article 2082, the one on being subordinate to civilian authority. 128(2), Mr. Chairman, 128(2) is that all organs and agencies of the state shall accord to the courts such assistance as may be required to ensure the effectiveness of the courts. Effectiveness of the courts includes its judgments being binding, being applicable to everybody until there is a contrary position. Michael I would pray, Mr. Chairman, that that question also be allowed. We had proceedings. I'm still in Article 28. 1. The tribunal, an organ of the defense forces, which investigates an offense, charges the accused, tries the accused, can be considered impartial in any way. And this is not to say anything about the character of the fine officers and men who constitute the court. It has nothing to do with their individual, it's the institution. How can you be a judge in your own cause? How else can you find prejudice other than being a judge in your own cause? The charge sheet tells us about offenses relating to the defense forces. So when we ask that these matters move away from here and go elsewhere, we are simply following what the Constitution requires. Yesterday we had we've had these engagements with the judge advocate, my good friend, but from this side and that side we're always having contestations. But just for purposes of impartiality, the panel, and also yesterday we went through what the panel, consists of. But we found a regulation. This is just an example. Regulation 69. So yesterday we had an issue around the judge advocate and whether his views are binding or not, the advice given and so on. I'll address that shortly. But there is also another one which I want to give by example. 69.2 says that a court may adjourn, it is referring to the court martial, may adjourn at any time to consult the convening authority on a point of law. This court is supposed to be complete as a unit, discharging its work alone. Everybody who is a member of this court should be in the court. I checked on who the convening authority is. It's the High Command. Now, if a court will adjourn or can adjourn or is empowered to adjourn or is allowed to adjourn to consult the High Command, Mr. Chairman, Article 28.1 would have no place. But this regulation cannot apply above Article 28. Impartiality. So, we also pose this question. In the circumstances where we are, where the defense forces are the complainant, the investigator, the witnesses, the judge, is a trial before the court martial consistent with Article 28.1? Is it? Can it be? We submit. That question needs to go for interpretation. There are other factors dealing with impartiality. They have to do with the tenure, security of tenure, and so on. So in the other civilian side where we are maybe a little bit more familiar, We know that there is sanctity there. There are provisions that protect, that reinforce, they protect the judicial officer.
So we have a challenge. Going back to the other.
If the court is bound by the advice of the judge, who is not a member of the panel, who is making this decision? And I say this, I have said again, I will emphasize, it has nothing to do with the character of the individual. It has something to do with the structure of the law.
If indeed my learned friend's advice is binding, why is there a panel at all? So, Mr. Chairman, I want to pose a question, and the judge advocate's power is in Regulation 63(2). Whether Regulation 63(2) and 69(2) of the UPDF rules of procedure regulations are consistent with Article 28(1) of the Constitution. Honorable Chair, Article 137 of our Constitution deals with the interpretation aspects, and the interpretation of the Constitution can be done in two ways, one by way of petition, the other way by way of reference. Even the one of reference has two limbs, one where the court itself considers it necessary, if in its opinion there is a substantial question of law. But the second one is where a party to the proceedings requests for a reference. The word used is that the court shall refer. If any party to the proceedings requests, the court shall refer the question to the Constitutional Court for a decision. And when that reference is made, the case will be disposed of in accordance with what the Constitutional Court has guided. Mr. Chairman, a fourth question arises. Perhaps this morning also. And it has to do with Section 208 and Article 79(1) and 129(1) of the Constitution. And we want to ask the question whether that Section 208 is contrary to and convenes Article 79(1). Parliament makes laws for Uganda. For the governance of Uganda. Parliament doesn't have power to set itself outside, even 1 centimeter outside the boundaries of Uganda. We contend. 129(1) has to do with judicial power being of Uganda. So, in our view, Mr. Chairman, there is a question that we want to be interpreted. The place of Section 208 and Parliament. Honorable Chair, the framers of the Constitution, who incidentally also include one of the accused persons, envisage that at one point, as life goes on, there may arise a contestation between individuals and the state and organs of the state. That is what this 137 is all about. So, Honorable Chair, as I end, and my colleagues will supplement on other questions, but as I end, it is our contention that there are very serious questions that have arisen, which on the face of it, and this is the only requirement from the authorities, on the face of it require interpretation of the Constitution. They are not before a field court martial because that is the only time, that is the only court where you can't make a reference. For all other courts, you are allowed to make a reference. A party is empowered to make the request, and when they do so, the court shall refer the question. I pray that the 4 questions that I have posed be accepted and the reference be made on those and any others that my colleagues may add. Mr. Chairman, before I sit down, I also want to draw the attention of the court to another law, the Human Rights Enforcement Act. The Human Rights Enforcement Act is now Cap 12. In Section 11, the consequences of derogating from non-derogable rights of a person are spelled out. Those who do so commit offenses. That's the first consequence. And as far as that consequence is concerned, the offense, even 10 years later, the person who committed it can be charged and is liable to sentencing up to 15 years. Brought to the attention of the court, that's the second consequence. The court is required to declare the trial a nullity. It's a heavy burden. It is a serious issue. So if we try civilians, contrary to Article 28, a non-derogable right, in the face of decisions of civilian courts to which we are subordinate, we are committing offenses. In fact, the court is required to declare that trial nullity, acquit, and discharge the accused person. The defense forces are capable of abiding by the Constitution and the Human Rights Enforcement Act. This court, I am sure, is capable of abiding by the Constitution and the Human Rights Enforcement Act. And I invite it to do so with utmost respect. Mr. Chairman, I invite my other colleagues to supplement, but that is our prayer this morning.
Thank you, Mr. Chairman. I'm adding, Mr. Chairman, for emphasis, and my colleagues will come with other questions. Mr. Chairman and members of the court, the first question that my colleague raised, and I agree with him entirely, was in respect to the uncertainty of the offense, whereby when you do and do not do, you commit an offense. So if we are crossing a road, essentially we have an officer saying don't cross, so that when you cross, you are disobeying an order, and you have one on the other side saying cross, yet when you cross, you're disobeying the other one. The point I'm making, Mr. Chairman, is that the necessity for a law to be clear, not only to members of the distinguished UPDF, but everyone, is just so that they know when they are conducting their affairs, when they are out of the or within the law. And for emphasis, Mr. Chairman, again in the case of retired Captain Amon Biarugawa and others versus the Attorney General, Constitutional Petition 44 of 2015, the court addressed itself. I will just refer to a short quotation so that I can emphasize. Citing an American case, Colenda versus Lawson, the court was of the view that, as generally stated, the void requires that a penal statute defines the criminal offense with sufficient definiteness that an ordinary person and not prohibited, and in a manner that does not encourage arbitrary or discriminatory enforcement. The rationale, Mr. Chairman and members of the panel, is that I should know whether to cross the road or not to cross the road is an offense. That was an example, but also it is intended for an ordinary man. Mr. Chairman, in society we have individuals high up there, we have individuals in the middle who we ordinarily refer to as reasonable. They are not far off. And then we have the others who are lower, who in different aspects are referred to as the riffraff of society. The requirement for a law to be certain, law as itself to the lowest in society. The law should be very clear that an ordinary person, the lowest in society, is very sure about how they are going to conduct themselves. And that submission, that offense which says to do anything or not to do anything that constitutes or compromises the security of the defense forces means that I am effectively at a cross junction. I don't know whether to go left, right, north, south, east or west. The other one, the third question my colleague raised was in regards to the court being impartial. Mr. Chairman, the courts have recognized that military courts, like the one we are in, is intended to charge or to try officers for disciplinary matters. And of course, in our UPDF Act, there is a clause which brings in the civilians. But again, Mr. Chairman, the courts have made a pronouncement about the character of the executive, and therefore the officers forming the courts being subject to the executive. And the courts have made it clear in the case of the Second Lieutenant Ambrose Ogwang versus Uganda. It says that courts which have to try any civil or criminal matter must be independent. It's a command under Article 28(1), and the courts have said by virtue of the appointment of the military court is not independent. Mr. Chairman, we are not making or referring to the individuals because who are before us, before whom we are standing, because we know that theirs is an appointment and they are executing the lawful mandate of their appointing authority. So it's not character of individuals, it is the institution, Mr. Chairman. Because I've said military courts are not independent and that they are military courts of the executive, they belong to the executive. Moreover, the charges they try are brought by the army. And Mr. Chairman, the court made reference to two sets of people. Those who are not subject to military law, I suppose like me, and those who are subject to military law, I reckon, Mr. Chairman, like yourself, Mr. Chairman, and the officers before us, because they are soldiers serving, doing a national duty of protecting our country. But it said that persons who are subject to military law, like every other person in this country, enjoy fundamental rights which may only be limited in a manner allowed by the Constitution. He said that judges of independent courts cannot be under the administrative control of the authority that brings the charges. In this case, my Lord, Mr. Chairman, rather, to the extent that the court is of the institution of the UPDF, and the offense that has come, one of which is to compromise the security of the UPDF. Again, it shows that the institution which placed all these gallant officers in their offices, which they're executing, is complaining before